Happy Monday, everyone. It's Lauren Conlon and Jarrett Ferrantino. We would like to discuss, or mainly Jarrett would like to discuss, the preliminary motions that have been filed by pretty much all of the defendants except for Tiffany and Cora. I don't know why theirs has not shown up yet because the judge gave them until September 9th, which is, that's today. That makes sense. Okay. So they took until the very last minute. So this is me putting the dates together. Yeah, that just shows you my brain power right now for a Monday morning. But so these women most likely will file today the motions about having the defendants all be tried together, whether they are for it, against it. And we have some differing motions here, right, Jarrett? From Tad, Paul, Cole. It's really interesting. So
there's been a lot of preliminary hearing activity, which is kind of rare. But when you have 5 defendants, that's a lot of moving parts, as we've said. So you sent me a series of documents that have been filed. I'll break them down in the order that I received them and reviewed them.
Okay.
So the first one was this: Tad Cullum has requested to undergo an MRI or CAT scan of his stomach. He's apparently having some medical issues in jail. That request was made and the state is responding. So this is a little bit of a weird territory. As prosecutors, you find yourself sometimes addressing issues that really aren't in your purview, like the medical care that Tad Cullum receives or lack thereof really isn't the prosecutor's deal. But if the request was made under this caption, which means in this case, the prosecutor can't leave an uncontested motion out there. So the prosecution has responded to that request and says, number one, Tad has provided no authority that would justify his being released for an MRI or a CAT scan, basically allowing for the judge to let that happen. In addition to that, the prosecution says, hey, the sheriff is the one that runs the jail. We have really no jurisdiction, and the court at this time really has no jurisdiction to make a decision without the sheriff being involved or the sheriff occasioning that request. So really,
Texas County, Jarrett, or
yes.
Okay.
Yeah, so the sheriff basically would have to either join in that request or become a party of that request. So essentially the state's objecting to allowing for him to get an MRI. Now, that really, in addition to that, there is some medical evidence that the state put forth in their motion, and that's their doctor, the doctor of the jail, says the condition will go away and an MRI or CAT scan aren't necessary at this time. Now, I thought that was good. They put that in there. It shows that they're not ignoring. I mean, look, you can't ignore a defendant who's presumed innocent at this time if a medical issue is raised. So in addition to providing legal authority, they provide some medical evidence and authority in support of their position. I am sure the judge is going to grant the denial, not grant the or deny the request.
Okay.
And direct those lawyers to serve the sheriff if they want to continue to pursue this care. But based on the medical evidence, it may go away even prior to that. So
let me ask you, though, why did he not, like, if you have this condition, why would you not have your doctor maybe scan some? I know, I guess there's HIPAA and everything, but why can't you prove that? Why did he not prove that he had this condition? Because right? Like, I don't get it.
I think, first of all, this could have been a request he made of his lawyers on the fly, and they wanted to get it before the judge. It doesn't appear that they've put medical evidence forth in support of their concern. They may do that. I don't know. I don't know what's going on with that. But you're right. If it's truly a pressing condition, to put his physical well-being at issue before the judge, you better have some medical documentation to support it.
That's what I was thinking. So I'm not saying he's making it up to, get away with something else. I'm just thinking, if that's me and it's really important and I've been dealing with this for X many years, X many months, I'm going to put that forth for the judge. But hey, that is just
and it could be a condition that's developed since he's there. So there may not be medical documentation outside. But let me say this too. Yeah. When you get into these issues of jail conditions, security classifications of a client, these are fights that I've had in courtrooms. It's a really odd fight to have because you are out of, not to say your comfort zone. I mean, look, putting people in jail is our comfort zone as prosecutors. That's what we do. We arrest, we charge. Whether or not someone's going to be held is something we argue. But when we're talking about actual specifics and logistics of confinement and classification and care, I know everybody assumes we all work together with the jail and we all, we're all one and we're all in these backroom deals. That's not the case. I mean, so you run into jurisdictional issues. So this is one of those situations. If I'm talking and advising Tad Cullum's lawyers, get the sheriff involved in this if it's a pressing thing that has to be addressed.
You made me nervous about something, and we talked about this before, but I had mentioned that Cole's brother is the sheriff of Cimarron County. I mean, these counties are pretty close together, and I'm certain that the sheriffs speak, right? They have to, and the sheriff is pretty much in charge of the Texas County Jail. I mean, who's to say that no one's getting any special privileges, or you know what I'm saying? And I know you have no proof of that or whatever, but
again,
that's why people are nervous.
I would say that is a legitimate concern of people. You hope everybody's doing their job. Look, in these small towns, and you have a lot of people charged in a case that impacts a lot of people, you're going to have these kinds of relationships which present conflicts. You just hope everybody's doing their job. Any failure to do their job, look, a sheriff who provides favorable treatment for an inmate that's a relative runs into a real risk of losing their position. So you hope that they follow the law. We certainly aren't aware of any situation to date that hasn't happened, or any accusation certainly made publicly or in the filing. So my hope is that everybody's doing their jobs. This is just such a heinous crime. You hope they're not circling the wagons to protect family members like that. And I'm not being naive. I'm saying legitimately, I'm hoping that's the case. If it's not, it gets raised and addressed.
Yeah. So I would hope, and I would think that there's just extra eyes everywhere across these 5 suspects with some of the connections. But anyway, continue.
So the other motion that was filed was Cole Twombly, through his lawyers, has agreed to a joint preliminary hearing. Mm-hmm. So that basically, what they're basically saying is that hearing on December 17th, which is the preliminary hearing, that lower standard showing, that mini trial where they're going to call their main witnesses to testify broad strokes about what we have here, is going to be held with all 5 defendants together. And that's only before a magistrate judge. And Cole's lawyers are saying, hey, in accordance with the rules, and it's Rule 439 in Oklahoma, we don't see any real prejudice to Cole if this particular hearing is held jointly, because it's not a jury situation. It is a magistrate judge, and they're saying, Judge, you can take the evidence that's presented, consider it against, if there's a piece of evidence presented against Tad, you will consider it only against Tad. You won't consider it against Cole, for example. So they're saying you can parse out the evidence. So this all comes down to whether or not a case should be joined, and they call it joinder in the law. So initially, Cole's lawyers don't have a problem. And I'm going to tell you, the law is pretty clear on this. If it's before a judge and there's no real issue to split these cases at this point, it's going to be held together on December 17th. So at this point, Cole is in agreement with that.
So, and let me just break this down just in case people listening, aren't familiar with everything. So he is not saying that we want to officially be tried together with a jury. This is just a preliminary hearing with a magistrate, almost like what they did with Corey Richins, I want to say, where they had all the witnesses, they took and they decided what they were going to charge her with exactly, but not in this case, I guess. What is this? I guess I don't. Yeah. What is this preliminary hearing
So a preliminary hearing is, you have a constitutional right before a case is gotten on to really simplify it. Before you go to the big courthouse, you have a right to be heard at a lower court. And the standard is not beyond a reasonable doubt. It's prima facie, which everybody hates Latin, but it basically says, look, it's more likely than not a crime's been committed and these are the people that did it.
Right.
and they're held. Their bail is often reassessed at that point. And basically, it's just a constitutional protection in our system that says you cannot be arrested and held without an initial showing of the prosecution to the defense that we have the right people. Here's the evidence we have preliminarily. And you have to understand, discovery hasn't happened yet. Cross-examinations aren't as extensive all the time as they would be if the defense had everything. So really, this is just preliminary hearings were a nice opportunity to put on your case, show the defendant what you have, push probably for a plea sometimes, maybe not in this case, but really have the opportunity to examine those witnesses for the first time. They're often in smaller courtrooms. They're often very intimate. They're often right shortly after these crimes have occurred. Highly emotional proceedings. I've had some crazy preliminary hearings.
So families can listen in to these.
Oh, yeah, they could attend. They could attend. Now, unless there's a security issue, and with all 5 defendants in Oklahoma, I don't know where they're going to put them. But yes, typically the families can attend and members of the public can attend this proceeding as well.
Let me ask you, did they decide at this hearing whether or not they could face the death penalty?
No, all of those. No, this is just a magistrate judge. So this is a lower court judge who's just saying that preliminarily there's enough evidence to send the case on. The rest of that stuff happens at the bigger courthouse with the district judge. The other thing is, oftentimes the notice of the death penalty doesn't come till after that. Now I know it comes at the time of the arraignment at the formal courthouse too.
Okay. So Cole is saying no problem if we're all heard together on this, as long as the magistrate can separate that this is for Tiffany, this evidence, and not for me, and it's widely known. I guess so. And I'm sorry if you said this and I didn't understand it. So what is the goal? What do they walk out of there, the defendants? What do they walk out of there knowing that they didn't know before, or the public that they didn't know before?
Well, the defendants are given the opportunity at this point to see some of the initial evidence they may not have seen yet. So it's a little bit of a discovery expedition, but that's a collateral benefit. Really, it's the preliminary hearing is for the defendant. It's to show them that you're the person and we have some evidence to hold you. If you don't have that evidence, the case could get thrown out.
Okay. There's no way this is getting thrown out. I mean, come on.
I don't see that.
There's no way.
But I've seen cases dismissed at the preliminary.
Barry Morphew, right? Didn't that get dismissed?
I believe his was dismissed there. And I mean, I've personally had cases where witnesses didn't appear. You have to refile. It's a whole thing. I mean, it happens sometimes, but I don't see it happening here at all. No reason to think it's going to happen here.
Okay, got it. And so the last hearing, they had said Cole's preliminary hearing is set for December. And at that point, it was just him alone. And he's saying, no problem. Just, we can do it with everybody. Okay.
Yes.
Got it.
Yes.
Got it.
So the next issue is Tad and his lawyers have objected. There appears to have been a forfeiture filing of a 2017 Ford F-250 truck and a John Deere skid steer. Yes. So basically the truck that we've talked about in this case, a truck that was used in this case, and the skid steer that would have been used to bury the bodies here, have been filed for forfeiture by the prosecution, which means we're going to take these items and sell them. Okay. Now, I have some concerns here with this particular filing. Number one, I don't know what the rush is to sell this truck and this skid steer.
Why do they want to? This isn't the truck. I think this is Tad's mother's truck, not Cora and Cole's truck, if it's Tad's. But why? I don't get why they want to sell it.
Explain. Well, you can sell it. First of all, when a prosecution is holding a particular vehicle, you incur storage costs and things of that nature. So the goal is to not have a evidence car yard full of vehicles. Okay.
Yeah.
But this case is brand new. I don't know why they're moving so quickly to get rid of these vehicles. And the defense is saying, at least Tad's defense lawyers are saying, wait, whoa, like under Brady, under the 14th Amendment, we have a due process right to inspect and examine these vehicles. We don't even have discovery yet. We don't know where they fit in. It's almost like the Koberger house, right? When they were knocking down that house, everybody was up in arms. But the defense had multiple occasions to go to the house, laser map the house, test the house, all of that. Here, they're saying, we didn't even look at this stuff yet. What is your rush to sell it? Now, the problem is a forfeiture filing is a civil filing. It's not necessarily criminal. So it appears that Tad and his lawyers were not notified of that filing. So they're saying, hey, the DA is trying to forfeit material evidence in this case and sell it off. We weren't notified of the hearing, and we object to it being sold prematurely, just like they've objected to the premature return of our victims' properties back to their families. Same reason. The judge would be well advised to say, put the brakes on selling this stuff until everybody has a chance to examine it. We've talked about it. It's going to be a year before we get to trial. They're not going to bring that skid steer into the courtroom. They're not going to bring the truck into the courtroom. But at a minimum, give the defense and their investigators the opportunity to photograph, examine, visit the scene or view the truck. It's way too early for that. I don't know why that's happening.
You think it's too early for the state to be selling all this stuff off. And
I know why it's happening. There is a forfeiture DA in that office, I'm sure, who's just never misses an opportunity to forfeit something and turn it into cash, and he or she is doing their job. The problem is they're doing it a little bit ambitiously.
Because that money, the forfeiture money, will go straight to the county. And so it's like
that money would be held within the deal. But again, that's that person's job, always looking for evidence to forfeit. Or you could forfeit a vehicle like that F-250. If it's a nice truck, it could be used in drug investigations and things of that nature. So,
and did the state respond? I don't think they.
No, it looks like, but again, even if they do, it may even be under that civil number again. So I'm sure the state's going to respond, but the judge, I would think, is going to deny this request to forfeit as premature. I think they're well within the right. And the final thing we looked at today was Tad's lawyers joined in the return of property objection as well. Same thing. The Brady case that stands for the accused's right to inspect any evidence against them, and the prosecution's obligation to turn over evidence against them. So again, I think that the judge initially is going to say, put the brakes on the return of that property, put the brakes on the forfeiture of those vehicles, give the defense the opportunity, and ultimately we'll get this done down the road. It's a little premature, if you ask me.
Yes. Okay. But you got the Paul Grice preliminary hearing joiner of defendants as well. Did you see that?
No, let me see.
I'm like, I know, I sent you a lot. So that one, let me send it to you again.
Can you pull it up on the screen? Is he basically, so what is Paul saying?
So he's saying, he said he also cited 438 provides the court may order 2 or more indictments or informations or both to be tried together if the offenses and the defendants, if there's more on run, the procedure shall be the same if the prosecution was under such single indictment or information. Unlike an objection to joiner defendants. Yeah, it sounds like here. Actually, I'm not even going to assume what it sounds like. I'm just going to pull it up and have you take a look. And also, if you want to look at my text,
it sounds like he's agreeing too, but I'll look at it.
No, I think he is. But if you want to look at my text, I also sent you, the first thing I sent you was Tad's response to everybody being tried together. If you want to pull that up, but here's
that one we did. So
Tad, we didn't do Tad being tried together. He strongly objected that. That's like,
Cole's we did. So
Cole's we did. So here's Paul's. Let me pull this up. Can you see?
Yes. So preliminary hearing joiner. Let's see.
And I'll go to the next slide once you've read through this.
Okay, what's the next page say?
Yeah, it's only 2 pages, so we're good. We're good here. And I'm going to...
Okay, so...
Yeah, while you're discussing, I'm going to pull up Tad's as well.
They don't as clearly agree with the joinder, but they're saying, we acknowledge you have the right to do it. So it doesn't sound like they're strongly opposed. They're saying there's no cases that say this impacts their ability to make a request to sever these trials down the road. And I think that the arguments they're making in that motion are preserving the right to challenge this later, but accepting the joinder now.
Sorry. Okay. So, and just to be clear, I may have misinterpreted this. What they are filing and what is due today on the 9th is not for the actual trial. It's just for December.
That's correct.
I did not get that. I literally thought that it was for.
It's too early to make that objection for the trial because, as I've said, the objection to them being tried together really turns on the question of what defense they're taking, if they're taking a defense. And if they're accusing one another and that rears its head, then the likelihood of them being tried together is lessened. Okay. It depends on who's saying what and how they're saying it, who the witnesses are. So again, it's early in this process, which will be painstakingly slow, but the defense doesn't necessarily have all the information to make a great argument about severance and severing the trials yet.
Okay, so this is all for the December preliminary hearing. And so far we have Cole and Paul saying.
Okay, go to the next page on that one. I read
that. Cole and Paul saying, it's fine, we don't care. And now we have Tad coming through and saying no. And we don't have Cora.
Yeah. And right here, it says the trial would place the defendants in an antagonistic position toward one another. That's the very thing I just said. So go to the next page. How long is this thing?
No, this is long. This one.
Yeah. So they're okay. So basically so Tad's opposing the joinder. His lawyers are saying, and just generally, we could just generalize it at this point. They're citing. So they're citing federal case law that says they have the right to object to this. A high risk of prejudice exists if they are tried even at a preliminary stage together. And I'm only gleaning that from what I read. So look, I think that his lawyers certainly have the right to make that objection. However, we are not in federal court. We are in state court. So the state.
Yeah, why would they cite federal case law for a state?
Well, that's a good question. But the answer is federal law could be persuasive authority over a state court. They could say, look, we don't have any clear answer to this at the state level. However, in federal court, it says this could be prejudicial. That being said, so far, one defendant has opposed this. These preliminary hearings are going to be held together. So again, I could be wrong, but
I don't know. What do you? I think Tiffany maybe will. I think
she'll object to it. She will absolutely.
So I was going to say that most likely she would object. Cora, based on her attorneys, I feel like maybe she would object as well. But that one's tough. I don't know. Just based on what her attorneys have been filing thus far.
Yeah, even if they do, I still see it being held together. So I get their objections. They certainly have the right to object, but judicial economy, convenience, the fact that we're at a preliminary hearing, all those things considered together, these things are going to be held jointly. All 5 of them are going to be brought in at the same time. If they're not, I would be surprised because the issues in play right now aren't as serious as the consideration for down the road. Not to say they're not serious. I don't mean to simplify it, but they're nowhere near as paramount as whether or not the trial before a jury should be held together.
Okay. And in December, these hearings, how long do they usually last?
It could be several days. It could be over a week long. I mean, I've had preliminary hearings for murders that lasted several hours. I've had some that lasted several days. So with this case, you're probably looking with 5 defendants and the scope of this case, you're probably looking at at least a 3-day hearing.
Yeah. Why would they do it right near Christmas? That's weird. Do you think that's...
I mean, I've had murder trials with Christmas carolers singing in the rotunda of the courthouse. Believe me, it's not great. But
no, it just seems like not.
The wheels of justice don't stop for the holidays. What could I tell you?
You know what I mean? Like, it seems weird for the families who might not want to spend the days leading up to Christmas in court looking at those mugs. Okay,
it sucks, but the reality is
Ah.
there's never going to be a good time for the families to endure that. So
Do you think it'll be televised? Nothing has been televised inside the courtrooms thus far.
So that would suggest to me, and I haven't looked at this, that the Oklahoma courts do not have cameras inside. In all likelihood, it would not be televised. So
Especially with a gag order
we'll
right
check
now?
on that, though. We'll check on that. So let's check on that. But if they
Yeah.
have not been televised thus far, then in all likelihood, the hearing itself won't be televised. The other thing is, I know that the families are going to have to go through this, but this hearing is going to be bound over. So they're going to get some good news before the holidays. Basically, like the case is moving forward. If you wait past the holidays, you're into the new year. I mean, they got to get this thing going.
That's a good point. They probably will get some quote unquote good news, as good as you can possibly get, about this case. But does the gag order mean anything about it not being televised, or that's just preliminary stuff?
No, so the gag order is different. A gag order is whether or not people can speak. And we'll go back to Kohlberger. There's certainly gag orders in place there, but then there was the question of whether or not Judge was going to allow cameras in the courtroom. So that's a separate question. But we'll look into whether or not Oklahoma allows it.
Yeah. Okay. All right. Well, thank you, Jarrett, for breaking all this down. I understand everything so
It's a lot for a Monday
much better. It is a lot. And I was completely confused because I thought this was like, and I thought it seemed fast, where I was like, wait, and it's just funny where it's like in my head, I was like, it seems weird that she wouldn't hear these arguments in person, or she, or whoever, the judge, which is a man actually. Yeah, and now it all makes sense. They're filing motions for the preliminary hearing. Okay, Lauren.
Right.
Okay, get it now. Okay. Well, thanks, Jarrett. Have a great rest of your day, and everyone, thanks for
Thank
watching.
you.
I hope this was provided some clarity for everybody else.